I see that. Got a pencil for follow. What do you
Yes, I have counted it wrong. Yes, admit I have counted it wrong. It's not a Morgan Stanley because that I've learned.
No, this is a Morgan Stanley, not a Stanley Morgan.
Unfortunately, maybe in some cases I've seen that. So I'm a little bit confused. It is actually Morgan Stanley. Yes. Now I have checked up. I've seen. I remember the same thing that was happening in other court. Anyway, what I've learned, if you say something wrong in open court, you must come and concede, yes, I have committed wrong. At least that I've learned from our senior.
Is what our grooming was.
এই দেখো আবার এখানে কিছুই তো শিখিনি বলে লাভ নেই। কি আরে সারা পৃথিবীতে যেখানে গেছি তার দেশের ল্যাঙ্গুয়েজে আর্গুমেন্ট হয়,
ওটা হয়েছে
বুঝলে? এই নয় যে এখানে আমি প্রথম করছি।
My lord, with regard to item 5, kindly fix a specific date.
What?
Specially fix, my lord, it will not be taken up. It seems, according to the note. Kindly fix the next, week, my lord.
Will fix, don't worry.
My lord,
Indicate at least 2 days before.
also here. Excepting Friday. Friday, my lord, I have got 2 other benches with seats at 2.
See to it, don't worry.
Excepting Friday, my lord, any.
Yes.
my lord, I am mentioning item number 71 under the compelling circumstance. Mr. Bari is my is the opposite party. I am appearing on behalf of the appellants. My lord, we are facing a contempt, and today
It was called on, I think, entire application.
71.
71 was called on Monday, I believe. Entire list was called on Monday and Tuesday. All applications we finished.
Can it be taken up at 1 o'clock? Both
Hey.
sides are here.
কোন দিন আমাদের পুরো অ্যাপ্লিকেশনটা ডাকা হয়েছে? Monday or Tuesday, I believe.
He was not
Nobody
there.
responded.
He was not there in the
Just
matter.
wait. We'll fix
But,
this matter
today-
tomorrow. We'll fix some matters tomorrow. Don't worry. We'll take up. Because we could not touch order 41 for at least 2 weeks, so we wanted to.
Only difficulty was that today at 2 p.m. the personal appearance is there.
Let us see.
So, my lord, if you lordship takes her at 1 o'clock, both sides agree to that. 5 minutes. 5 minutes, my lord. Lordship
For dismissal.
Issue has already been
Lord-
decided by your lord.
Lordship judgment is, my lord, issue is there. Judgment is there, my lord. But only a very
Like the Procedural judgment of Procedural. Let it-
that I have read that judgment. I am not on merit, my lord. I am only seeing one way or the other. Lordship kindly take up this matter, my lord.
Let us see. Let us see. Yes,
Should we come at 1 o'clock?
Come at 1.
Grateful.
My lord, on last Monday I came before Lordship. I mentioned for inclusion hearing. Your Lordship directed me to come today. But then this is also organized feature. My lord, it is in the last.
এই নিয়ে নাও বলছেন যখন
My Lordship, serial number 272 of the combined list, Lordship, may it be upgraded. There's an application
What?
connected. Lordship, 272 of the combined
we'll
list.
take up applications for contempt and all everything from on tomorrow.
Very good, Lordship. May it be
Tomorrow we'll take up.
very.
My lord, may I permitted to mention a matter for inclusion, my lord?
Which one?
My lord, a new matter, my lord, for inclusion.
Application.
Yes, my lord.
Praying for my lords, kindly to mention a matter for inclusion, my lord.
Application.
My lord, appeal under order 41, rule 11.
Oh, order 41.
Grateful, my lord.
Yes, call the list.
My lord, may I indicate 2 things which will assist my lord? I'm sure he's coming.
Oh no, where is Mr. Banerjee?
He's honest.
He admits he was wrong.
Morgan Stanley and Stanley Morgan. My lord, kindly take the deed of sale in favor of my lord.
What?
My lord will kindly take the deed of sale which was made in.
Not necessary. We were hearing him.
My lord,
I have seen.
the
What you
property-
have not seen, I have seen.
just to indicate the property worth 40 crores. Well, market value was
93
sold for
lakhs, I
1
have
crore.
seen.
1 crore.
93 lakhs I have seen. You did not have to.
And this was done in violation of an order of stay passed by this court.
Whatever
injunction.
is there,
I will
and
indicate, my lord.
these markings are already there to some relevant documents.
Now, my lord, my lord has a copy of the plain, my lord. My lords have a copy of the plain, my lord. My lords have a sorry, একটু যদি দেন জজ সাহেব বলছেন নেই আমি কি করতে পারি
দেখিনি আছে একটাই আছে আমি জানি
না না একটা কপি দেখি দুটো ঠিক আছে না my lord, firstly kindly have a look at the cost type loan. My lord, who is the party? The person, my lord, who is representing, my lord, Ishwar Shitaran Ju, my lord, is claiming to be a Sheba. Now he comes or she comes, my lord, from the side of Ashalata. Yesterday, my lord, when it ended, your lordship, my lord, my learned senior friend said that, my lord, he's not claiming through Ashalata.
Still nodding on head in negative.
Not claiming through Ashalata. Then, my lord, in my respectful submission, then may I ask this question to myself?
Then he's claiming from whom?
From whom?
Is in medio or in limbo?
My lord. My lord, she is nowhere. Number one. Number two, my lord, she is a person who has to claim from Ashalata, my lord, because after Panchanon, the Shebaitship devolved on Ashalata. So he can't say today, my lord, that I am skipping my mother and I'm claiming directly through the grandfather. So that's one aspect in the matter. My lord, take everything for granted, whatever is there in the plane. Take everything for granted. On Mukto Keshi. Whatever is there in the plane, even then, my lord, he is not entitled to an injunction. Why? Firstly, my lord, she doesn't have a right ipso facto in the property. One. Second, my lord, even if she had a right, whether the suit is maintainable. In the absence of everybody, my lord, who can claim a right to Shebaitship. She is a daughter. Kindly appreciates this, my lord. She is a daughter from Ashalata. My lord, Ashalata had, my lord, Roktima, Runima, Aroti, and Shopna. And she is only Shopna. The others have not joined. Now she is claiming a right that she is a Shebai. My lord, she has not prayed for her Shebaitship. Now, if she has not prayed for a Shebaitship, my lord, then the suit is also bound under 34. Now, if there is an inchoate right, there is nothing there, my lord, on
34 lies. I have still strong doubts.
My lord, even
Your
after
Offernama cannot be regarded as a deed of trust.
no,
It is a religious endowment.
my lord,
Under the Hindu Religious Endowment Act, it does not provide any provision for taking a permission.
no,
The permission comes only under the Trust Act,
My
Section
lord.
34, if
My
it is
lord.
at all necessary. Section 1, subsection 2 or 3 of the Trust Act
My
says
lord.
that the religious endowment is outside the
Bow
purview
down,
of the Trust Act.
bow down.
If it is outside the purview of the Trust Act, one can very well say that, yes, that was absolutely not necessary. Suppose surpluses, superfluous, no credence should be given for that reason.
Man.
I can understand the argument. If I am there, I would have argued that.
My lord.
So you will argue.
That argument was made yesterday itself.
So this is what it comes.
My lord.
Only
There is
thing
another thing.
Only thing is that the question is not a Shebayasip in that sense.
My lord.
The question is the deed having executed. Having executed, in what capacity?
Now, in what capacity, my lord, we have executed that in the capacity of a Sheba.
Now, if the question is that if it's the capacity of a Shabat, then can you now turn around and say that it is a secular property?
No, no, no. I'm not saying so.
You are.
No, I have not said so. Milord, this is where the anomaly rise. I have never said so. Milord, that section.
Secondly, now I am telling because
My lord.
I have read the briefs,
My lord,
got the chance,
my lord,
calmly, quietly, I have to read.
my lord.
You have said in the recital of the deed that on the basis of 29th deed
Yes.
of Arpanama,
Yes,
this right has accrued
yes.
and now you wanted to do. The Privy Council has declared 29 deed to be
Milord, there,
void.
my lord,
Now it reverts back to 22 deeds.
my lord.
Now, so far as the 22 deeds are concerned, the question would be again a matter of evidence
Yes,
that whether it comprised or it does not comprise, but the act of the parties in the conduct is also one of the relevant factors
my lord,
in an injunction case.
my lord,
If the parties have taken a particular stand,
my lord.
then if they prevaricate their such stand, then the Supreme Court has also said that this is a good way of granting an injunction
Well.
because a litigant should not be permitted to prevaricate its stand at the different stages.
Absolutely. Bow down,
Not all of the litigation, but of the transaction
my lord,
or dealing with the property.
my lord.
So this is also one of the factors which comes.
Definitely.
Now, apparently there are something which has to be gone into, then
Ma-
why not the property be protected
Yes.
and be
So
not
we are just
further
on that.
dissipated by your act,
I bow down.
by
So,
your act.
so your lordship's consideration today is why not protect the property at the behest of a
Because the deed is the challenge. If the deed goes, then it will revert back to the hotspot of the obviously the DT.
Right.
DT's state.
Very well. In my respectful submission, so today what your lordship is considering is at the ad interim stage whether milord an injunction should be granted or not. Nothing beyond that. Now, my lord,
Now I must be very clear.
Absolutely.
Now this the stage of ad interim has gone.
no,
Now it's a stage of interim because we are hearing you. May not be on the basis of a pleading you are filing, but we are hearing you.
still ad
It
interim.
can't be said to be an ex parte one. It is really at the interim stage.
Subject to correction by my lords, milord, it is still ad interim because what your lordship is considering, milord, is an order which is passed at the ad interim stage.
Anyhow,
It doesn't become
I am
interim.
carrying the judgment of Justice Bhaskar Bhattacharya. Anyhow, I may
That
be wrong.
Jitesh Pandey's
Not
judgment.
Jitesh Pandey, it's a different judgment. The stages have been defined in that
Yes,
judgment.
yes, absolutely. milord.
Anyhow,
I'll tell your
I
lordship
may be
that as
wrong.
well.
You may be correct.
No, that is Jitesh Pandey. The stages, bro, I have it with me.
That is Jitesh Pandey's is three different concepts.
Exactly.
There is a subsequent judgment. Anyhow,
Very well. Milord, today, if your lordship is
we are hearing you and
your lordship is hearing me on at a stage where, milord, I have to accept whatever he stated in the plain to be correct, and even then, milord, he is not entitled to an injunction. Your lordship is not hearing me, milord, on my defense. I don't have a defense today before your lordship. It is on the basis of his plaint only. And I'm going back to Muktokeshi, milord, which your lordship opined yesterday. That's 88 Calcutta. Muktokeshi's first part was never touched. Bengal Club, milord, set aside the second
part has been touched,
Bengal Club,
which in my opinion should not have been touched.
then my lord kindly differs
Being
with
a coordinate bench, it should not have been touched.
then kindly differs with it and send it to a larger
It
bench.
was
I
not
don't have a
necessary
problem
because
on
I will
that.
refer
I don't have a problem with that.
constitution-based decision of the Supreme Court. And being the law declared under Article 141, I will say that this portion is wrong because it runs counter to the Supreme Court judgment.
No, I'm not even relying
No
upon
difficulty.
it. I'm not even
Why
relying.
I will refer to the larger bench? Should not.
My lord, if
Supreme Court is very clear.
my lord has taught us if there are two different decisions on the same
No,
coin,
operating in the field because
field.
there is no Supreme Court judgment. Then in that, if the Supreme Court judgment is very clear and it says that the subsequent coordinate bench cannot touch any of the ratio of law, but has to refer, and then says that this subsequent coordinate bench decision cannot be said to be a good law.
My lord, Bush.
Then in that event, we are bound more by a Supreme Court judgment than the
Bow down.
coordinate bench judgment.
Bow down. My lord, may I now, my lord? So now, before your lordship, at the ad interim stage, I am accepting the statements in the plaint to be correct. So today, my lord, your lordship is going to decide whether the trial court's decision of not granting an injunction at the ad interim stage is correct or not. So in my respectful submission, my lord, we have not crossed the ad interim stage because appeal, my lord, is really a continuation of the list. The list before the trial court, my lord, was the ad interim stage. So it hasn't crossed the stage of ad interim. So I am, in a way, my lord, arguing against myself and saying that today whatever is there in the plaint is to be taken to be true, and in spite of that, he is not entitled to an injunction. Lord, yesterday my learned senior friend with the judgment there, my Mr. Banerjee, my lord, made a very pertinent. Yeah, my kaka, my lord.
Yes.
He always makes a very pertinent point, my lord. His basic point was, এটা কি হচ্ছে এটা কি? ওটা তো আনরিপোর্টেড ডিসিশন, আমি ওটা যদি না দিই আমি কি করব?
চেম্বারে পেপার ছিল না, এখান থেকে প্রিন্ট হচ্ছে এক্সট্রা কপি।
Incorrigible, I tell you, lordship. Now, y'all
Control it, control.
the
Give us solace, give some.
yesterday, my lord, in the evening at 8:30, it's been given to him. Today we are at 11 o'clock. There are 20 juniors in the matter. They can't get, my lord, 2 copies of a judgment. And it's unbelievable. In our times, my lord, if we did that, my lords would have, my lord, chastised us and thrown us out of court.
এই তোর বাবা সিনিয়র আজকে পাস করতে আছে
কোথায় এসছে?
আইনে চলে যাবো
এসছে?
কতক্ষণ ধরে প্রিন্ট হচ্ছে?
এসছে?
ও তাহলে ভালো সই ভালো ঠিক আছে।
কাকা বলছে?
আমায় বলেছিল আসবে
জিজ্ঞেস বুঝতে পারছি না।
বল বল বল।
Now, if we had done it, my lord, when I had brought to him, by now, my lord, I would have been out of court. Now, my lord, this division bench says, of Justice Sanjeev Banerjee with Justice Shobboshaji Bhattacharjee, my lord, says that at the ad interim stage, the court has to see urgency more than anything else, not even, my lord, prima facie. Now, urgency, my lord, in that matter, my lord, it was the GPT healthcare matter, my lord. I'll cite it whenever, my lord, it comes. Your lordship will see, my lord, the court says that you waited for 7 days when you had knowledge that the other side was trying to make a construction. You are not entitled to an injunction. There is no urgency. So today, my lord, apart from prima facie case, everything else, my lord, the first thing that your lordship needs to see is what is the pressing urgency, my lord, that an injunction has to be granted. To that, looks to the plaint ones. Have a look at the plaint. The pressing urgency. Because I am not going to show, my lord, anything beyond that. His cause of action, sees page 17 of the plaint at paragraph 32. এলো না সকাল থেকে কি করছিল 11:10 বাজে?
এই নে, 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 কথা করছে।
22-এ মামলা করছিল, সকাল 10:30টায় চলে গেছে।
Yes.
ওকে, বাড়ি থেকে প্রিন্ট আউট নিয়ে আসা যায় না?
এই,
বাড়িতে না, আমার বাড়িতে নিয়ে যেতে হবে। Paragraph 32, my lord, is of the plaint. The cause of action of the above suit arose on and from May 2019. So his cause of action, my lord, arose on 2019, and he is claiming an injunction ad interim in 2025, when he doesn't even say that he's in possession. My lord, I'll show your lordship the paragraphs in the plaint. Your lordship will find no right to the property, no possession, not a declaration that she is a Shebayat. Whoever are in the, my lord, in the hotspot, they are not made parties to the suit. Her own sisters are not made parties to the suit. Who are made parties to the suit, my lord? And she claims to be a Shebayat representing, my lord, the deity. Have a look.
the application of paragraph 46, 60 পড়াবি আগে।
Have a look at this judgment, my lord. Your lordship will
একটা কপি দেখ।
এখন জি, হ্যাঁ।
kindly straight away, my lord, looks to paragraph 14. I read with your lordships, my lord. Unfortunately, on the my lord, your lordships. Have a look at paragraph 14. Here, injunction was granted.
Yes.
I read with your lordship, my lord. Unfortunately, on the basis of paragraph 14, my lord, unfortunately, on the basis of the averments in the petition and the grounds as to urgency indicated therein, the trial court in this case could not have been prompted to take up the matter with the kind of alacrity that has been shown. The trial court did not indicate any reasons as to why it was necessary to pass an ex parte ad interim order, and the petition did not contain adequate grounds in such regard. The construction had already commenced. That the construction had commenced on March 5 to 2017 could not have been the guiding factor in this case, since on the plaintiff's version, the plaintiff was aware from November 2016 that the appellant herein proposed to make a construction on the land to the appellant's possession. Even if the plaintiff had rushed to court within a day or two of the construction commencing, some modicum of reasons or rationale in its favor could have been discovered. But the plaintiff waited for more than a week before coming to court, and in between there was a complaint where the innocuous allegation was of the boundary wall of the plaintiff was being damaged, not of a person wrongfully constructing on the plaintiff's property. The only object of the present exercise is to ensure that trial courts are careful in exercising their discretion to entertain interlocutory applications ex parte or pass ex parte orders. It is only in the exceptional case that an ex parte order may be passed when it appears to the court that denial of the order at such stage would amount to the action being defeated or an irreparable injury or gross prejudice being occasioned to the suitor. Since the case carried by the plaintiff to the trial court did not meet such high standards, the trial court erred in entertaining the prayer for an ex parte order and passing an ex parte order. Accordingly, the order impugned is set aside. So here is a case, my lord, where even 7 days of delay, my lord, was said is not entitled him to, my lord, obtain an order. My lord, coming back to our case, 2019, my lord, he says that he came to know. The deed which she has challenged, my lord, is 2015. The first thing that, my lord, strikes, my lord, in my respectful submission, should strike the conscience of the court is, at the ad interim stage, where was the urgency? You are challenging a deed of 2015. My lord, there are judgments, your lordship knows much better than me, that even if you have a prima facie case, if the balance of convenience is to the other side, then the injunction will not be granted. At the ad interim stage, where you don't even show a right to the property, my lord, she doesn't have a right to represent the deity. Your lordship was talking about a reversion on yesterday, my lord. Kindly sees the scheme of the 22, my lord, deed, looks into it, whether, my lord, the property reverts back to her or not. Whether property, by property I mean the Shebaitship right. I'm not saying a property, my lord, property belongs to the deity. The Shebaitship right. Whether it goes to her, it doesn't. So if she doesn't, and she has not made out a case that she has become a Shebai, she can't, my lord, in my respectful submission, have a prima facie case to go to trial. My lord, a deed has been executed. In my respectful submission, somebody who has a right on the property has a right to challenge it, I bow down. But if she says that she has a right on the property and it's been registered in 2015, in my respectful submission in 2023, my lord, that deed cannot be challenged. At least at the ad interim stage, my lord, there cannot be any injunction in his favor because there is no urgency at all. Because whatever has happened in 2015, she says that she has knowledge the cause of action arose in 2019. So in 2023, my lord, there could not be an ad interim order of injunction without hearing the other side.
Yes.
The division bench says about 7 days. We are here, my lord, about 9 years.
Yes.
When the matter was initially moved before this honorable court, there was no prayer for injunction. my lord, if they had so much of a pressing right, my lord, so much of pressing, my lord, urgency, even then, the matter was heard at length before Justice Prasad. There was never a prayer, my lord, for injunction. Never. There were different lawyers at different points of time arguing. There was never a prayer for injunction. So if there was so much urgency, my lord, and I was doing whatever I had to do with the property, then there ought to have been at least a prayer for ad interim injunction. There was none. Now, this appeal has, my lord, is pending before this honorable court for 1.5 years. So ad interim injunction suddenly, my lord, from nowhere, just because you try and say that I have made some mistake somewhere, my lord, respectfully, this is not a public interest litigation. She needs to show first before your lordship that she has a right in the property. So anybody from anywhere can't come in and challenge pre-existing right. You are going back on the 22 deed very well. Kindly show that that 22 deed contain this property. Number one. I am on the basis of his own, my lord, Everman saying that the 22 deed did not have below the property in question. Let them show that once. I am saying on the basis of his Everman. Let them show. I'm challenging him.
Yes.
My lord, he has based his case on the basis of the 22 deed. That's his case. Sir, I mean, I'm distracted. Kindly, my lord, have a look at his plain, look at his schedule. Do not go into the details of the matter. Looks at this itself. Sees the schedule at page 21.
Yes.
My lord, kindly looks to page 21 once. My lord is looking to the judgment. Lordship looks into it. Plain.
Yes.
Now, kindly looks to 21 of the plain, my lord. Lordship has seen, my lord, it's a property which they are claiming a right on, is, or rather they've not claimed a right, they filed a suit on, is 1A Dr. Radhakumud Mukherjee Lane, formerly Cornfield Road. My lord comes back, my lord, to the 1922 deed. They're basing their right on that. And it looks to, my lord, his right, his own document at page, starts from 60, if I'm not mistaken.
Document starts from 58.
58, and below the schedule, your lordship will find at 70, 79. At 79. Kindly sees, my lord, whether this property is a part of, my lord, the suit property. This is 79. My lord, I am going on to tell your lordship also, my lord, that some of these properties mentioned in this 22 deed, my lord, did not belong to Sheetal at all. At all. So my respectful submission first is that the prima facie case would have come out first when the suit property belonged to the 22 deed. It's not there. At least, my lord, they have not been able to show your lordship. And I'm not basing this argument, my lord, on my documents. My argument is based on, my lord, his document. So if something that he is basing his claim on did not belong to the schedule of the property, my lord, ipso facto, my lord, there is no prima facie case. Forget it's about urgency. There is nothing. So 22 deed did not dedicate this property, my lord, 1A Cornfield Road to the Shebayatship, to the deity. There is nothing contrary, my lord, in the plaint itself, which says, my lord, that there was a dedication. Nothing. And this is not required to go into, my lord, evidence to show, my lord, whether 1A was a part of 22D. This is a document which you have produced. So if there was any doubt, you are the person who has brought in the property, brought in this proposition. So if there is any ambiguity, my lord, it goes against the plaintiff. Law of contra preferentum.
Yes.
So my respectful submission, my lord, is on threefold or fourfold grounds. First, you are claiming to be a Shebayat. There is a dispute with respect to your Shebayatship. How you became a Shebayat is not there on record. If there is a dispute with respect to your Shebayatship, there has to be a declaration praying for his Shebayatship, her Shebayatship. 1. 2. Even if you say that you are a Shebayat, you are claiming a right at the adversity, my lord, of other persons who are your own siblings. They are not made parties to the suit. If they are not made parties to the suit is not maintainable. If a suit is not maintainable, you are not entitled to an injunction. British Airways. Fourthly, the deed on which you rely upon, that deed doesn't have the property which you are claiming a right on. Fourth. Fifth, the deed that you are claiming a right on doesn't give you a Shebayatship. May not take it for instance that whatever I have done is wrong. Take it for instance, me going to 34, me getting an order is wrong. My lord, he himself has said that in that 34 application, he has obtained an order of injunction. Then I ask this question to myself, why does he need an injunction here?
Yes.
His plaint averment, my lord, kindly turns to the plaint once, turns back once to the plaint. At paragraph, page 10, paragraph 13.1. He says that he's obtained an order of injunction. Then where is the pressing urgency today before your lordship to obtain an order of injunction? May I ask this question to myself and for your lordship's kind consideration?
Yes. Yes.
কিন্তু প্রিন্টে তো ওরা বলছে ওরা করছে ওরা বলছে তো করেছে
তোরা প্লেনতে বলছিস তোরা আমার ওপেন করে
Rahul, are you sure? দেখো
it is there annex the document itself is there
দেখা যাক
147 146 or 148 you obtained the injunction violated it and then withdrew the injunction 147 148
off
You obtained.
Where is the order?
Page 147
147 or
of
what?
the stay application.
দাঁড়া এক সেকেন্ড আমি দেখে
আরে আমাদের predecessor।
Yes.
কিছু অন্য মামলা এই মামলা সেগুলো এই মামলা কানেক্টেড সেপারেট
What are you saying?
Yeah.
Can you read the plaint once?
What is annexed? What is annexed? Why should you look at?
Why are you showing this 147? How is it relevant?
It is irrelevant because you violated this order of injunction.
See the plaint and see what you are saying. চন্দ্রকুমার আগরওয়াল তোমার আমি ইনজাংশন নিয়েছি
Rahul, please take care. Take care.
See page 10 of your plaint.
Please go. Have time to go through everything.
তুই তো দেখাচ্ছিস চন্দ্রকুমার আগরওয়াল
ঘরে ঘরে ঝগড়া
তা আমার কি তাতে আরে দেখ
ঘরে ঘরে ঝগড়া
প্যারাগ্রাফ 10টা দেখ
তাজমহলের আগে ইনজাংশন নিচ্ছে এখানে প্লিট করে দে।
প্যারাগ্রাফ
রবি
পেজ
গান্ধী
10টা দেখ তো
ইনজাংশন নিচ্ছে এগুলো নিচ্ছে।
এটা কি হচ্ছে নাকি
কোন শুটিং এডিশন শুটিং আমরা ইনজাংশন নিয়েছে প্রপার্টি সব অর্ধেক অর্ধেক কাগজ দিয়েছে যেটা ওর ফেভারে সেইটুকু লাগিয়েছে কি দেবো এই জন্য তো বলছি ট্রায়াল কোর্টে চল ফুল প্লেজের আমরা অবজেকশন দিই পুরো হিয়ারিং হয়ে যায় এই গুলো রিপ্লাই দিতে গেলে তোমার ডকুমেন্ট গুলো নিয়ে আসতে হবে।
Yes.
Now, my lord, if your lordship sees, my lord has looked into that point. I don't know whether how they argue that. If they argue, my lord, because they did not argue anything. So my basic point is before your lordship, if I have done something wrong, take it for instance, I have done something wrong. X and Y have done something wrong. Y could have come up and told me, look here, you've done something wrong. You didn't have a title, this and that, and it goes. He is not a party to that deed. He doesn't have a right on the property which has been sold. This is not, my lord, a public interest litigation, not even a 92 proceeding. So he, even a semblance of a right to the property, my lord, why I say not a semblance of the right, because if he goes back to the 22 deed, your lordship will find that it has to go to a male descendant.
I have read it fully.
Fully. If it has gone to a male descendant,
Many other contingencies.
if there is, yes, there are many contingencies, but the utmost is that there has to be a male descendant. If there is a male descendant, the daughters don't have a right in anything whatsoever. Nothing whatsoever. 43 PV Council, my learned friend says that was all taken back after that consent decree came into play. All taken back once that consent decree came into play. If it goes back on reversion, Lord, it goes back to the male descendant. And there is nothing on record before your lordship which says that there was no male descendant. That's why I've become a Shebayat. Nothing on record. So you go by whatever document that he has given and kindly find out from where, my lord, she becomes, my lord, a Shebayat to the deity. That is the first thing, my lord, for him to obtain an injunction. Because he obtains an injunction, he has to have a right in the property. It's not, my lord, that anybody from the public will come in. It's not a public charitable trust. That 4 people, my lord, from the locality or from wherever comes in, files like a public interest litigation under 92 and obtains an injunction. No. The heirship, the Shebayatship are all defined in the deed itself. I'm taking, for instance, the 22 deed is there. I'm taking, for instance, my lord, whenever we have our chance, we'll put forward our defense to say, my lord, that the Shitol had died in 1918. So if I've done something wrong, I've done something wrong, my lord. Whoever is affected will come back. But today, she needs to show on the basis of her averment in the plate that she has a present right in the property, which has been infringed, and that she can represent the deity. Nothing on record. So, my lord, in my respectful submission, suit is not maintainable at the behest of a person who is not a Shebayat. One. If it is not maintainable, there can be no injunction. In my respectful submission, British Airways is clear on that. It is basically, my lord, a 3 judges bench decision, British Airways. If your lordship remembers, there was a difference of opinion between Justice Chatterjee and Justice Banerjee, referred, my lord, to the third honorable judge, Justice Kabir, gave a judgment, my lord, in favor where Mr. Mukherjee appeared, sided with my lord, the decision of Justice Chatterjee. So if the suit is not maintainable on the ground that all parties are not brought in the hotspot, well, take it for instance, if it was a partition suit. Cannot be a partition suit, but take it for instance, if it was a partition suit, everybody would have to be.
No,
So
that is a
everybody
different
who,
partition suit.
no, I'm
and
taking
the
an
other suits
analogy.
are two different.
Well, I'm taking an analogy. So if you say,
Not apt.
and hears me out, thereafter, well, hears me out. What I'm trying to say is that if everybody or anybody who would have maybe a semblance of a right to become a Shebayat is not made a party, the suit is not maintained.
I don't think so.
Then, my lord, pick and choose.
Don't think so, because the first and foremost prayer is the deed being impinged. And if the persons who are the executant of the deed and the person who is the recipient thereof, if they are made a party, then they have to be answered. What the others will come? They will come and support the sale. They may not support the sale. Nothing more than that. But it has to be decided or tested on the basis of a legal provision.
Very good. Very good. My lord, if that's what the law is,
Saying it is they are claiming any title, please kindly consider. You have been arguing so vociferously since the morning and even yesterday that they have not claimed any right in the property. I'm not talking about the immoral property. Here the subject matter is the deed, standalone. Can this deed be impinged or can this deed be not impinged? Whether by this deed any immoral property is transferred, or by this deed any right is created, or by this deed any movable property is there, if they can show that there has been an invasion of the rights
of
and whatever their rights,
their
invasion
rights.
of their rights, that is what I say you are correct to one sense. If they can
Grateful to
claim
Lordship.
that they are the invasion, there is an invasion of their rights, whether it contains a immoral property or not is not important. Only thing is affectation of their right.
Correct.
Now we have to decide on that basis,
Man.
whether to be made this party to that party. The conduct of the parties have to be taken into account. What is that? What is not that? If they died in 1980, if you take us to go into this aspect on an oral submission, then we'll have to make certain observations thereupon. I do not know which way it will go.
I take that as a threat, my lord, but I'm
not a threat.
I take that as a threat,
It is,
but
it is
I'm not even, my lord, getting into that.
It is neither a threat nor a sermonizing.
That's an observation.
It is merely that you are inviting the court to decide this issue.
My lord, I am.
We have to make
The
certain
problem
observations.
is,
We do not know which way we will make it.
my problem is, my lord, your lordship spend more years here than there. When you're, so is my predicament. I am making a submission before your lordship that do not decide. Why? Because there is no urgency. Go back. But your lordship is on merit. So I will have to.
Arguing non-party, non-impleachment of the necessary party, back to the bad. For that reason, I said that we have to concentrate on a plate. We have to concentrate on an injunction application. We have to concentrate on the documents which they connect with the injunction application.
Exactly.
Applications, and then see that
Man.
whether right.
Man.
Urgency, we'll consider that what does it mean? 7 days? Why not 1 day? Why not 2 days? Why not 24 hours? in a very recent time, I have decided one matter relating to a preemption right exercised by a person professing an Islamic law.
The preemption was came
1 hour delay was considered to be fatal. Can you imagine? 1 hour delay was considered to be fatal. My brother was there. We both, and there has been a judgment in this of a Privy Council of our High Court that says that preemption, if you want, the moment somebody utters that I have purchased, then and there you have to jump. Question is, I do not know 90 years old person can jump, but you have to jump and then claim that I have a right of preemption. If there is a delay of 1 hour, gone, fatal. So we don't know 7 days, 5 days from where this comes. We do not know. We consider that.
Yes. So I am trying to tell your lordship, Lord, my predicament. At one hand, my lord, I don't want your lordship, my lord, to go into the merits, but your
on the other
lordship,
hand, I want to make submission.
on the other hand, your lordship wants me to make submissions, my lord, on
No, I
merits.
don't want.
That is where my problem is.
Submission, we are reacting to it.
That's, my lord, I don't want to. My first submission was that where was the urgency?
Percolate a very strong message to the bench that if the occasion comes, I will say that he died in 1918. Obviously, I can understand that where you want to go. So we take it as the point of a defense, maybe oral. Then it will be we will be failing in our duty if we do not make any observation. That is not expected. An argument is advanced at the bar and the bench has not considered that argument. You have suffered.
Very well. So, my lord,
You have suffered in one matter.
many matters.
You were assisting me in that matter.
Yes,
You
yes.
have suffered.
Yes, yes.
Yes.
The arguments were not taken into consideration.
Yes, yes. And same honorable judge. I mean, Jitesh Pandey.
Anyway, it was not. It was totally bypassed.
I remember that, my lord, not very fondly, but we've used that judgment a lot, my lord, later. Jawaharlal Shah. But I don't know whether that's correct law.
Because subsequently, immediately thereafter, 2007,
Yes,
volume
yes.
2 or 3, SCC page 123,
Yes,
the three
yes.
judge of the Supreme Court accepted our view.
yes. Absolutely. Absolutely. And my lord, my lord, his lordship said that textile association was not considered. That's
Yeah,
why
1990 Supreme Court, 3-judge bench, Suraiya Begum
Suraiya Begum
Suraiya Begum took
and
into account
Amol
that
Aditya.
judgment.
Amol Aditya.
Amal Aditya, it was not considered at all.
Considered.
The division bench of the concept.
Dhiren Mitra, sir. Yes, that is, my lord, that
That's why
remains.
I thought, because I am also a sufferer, you are also a sufferer. When you argue something, then it is a duty, I think, ardent duty of the bench to consider and decide that.
I bow down. So now, my lord, what I am trying to first tell your lordship is, একদম কাকা।
No, he was the mischief monger in that judgment. Earlier judgment, he argues.
Amol Aditya, he didn't argue.
There was another judgment of Shakuntala Devi Kapoor.
Shakuntala Devi. Shakuntala Devi, he probably argued. তোমার কি বয়স হয়েছে শুধু ওই মামলা করাচ্ছে আমি তো
বেঁচে থাকলে আমি বলতাম এই ছেলেটিকে সামলাও।
আমি তো চাই না তোমার বয়স হোক আমি তো চাইছি তুমি আবার মানে একবার আর কি
জাজ কিন্তু গম্ভীর একদম অ্যালাউ করছে না।
So, my lord, to cull down, my lord, to what I am trying to tell your lordship is urgency number one.
Let me paraphrase what you argued. Your first contention is that this is against an refusal to pass an ex parte administrative order of injunction, so that the court, may I be very loud, you need not have to lend ears so carefully. I'm very loud. So first thing is that this appeal arises from an order refusing to pass an ex parte administrative order of injunction, so the court must confine its scrutiny or a consideration on the averment made in the plaint, injunction application, and the annexures thereto. Should not travel beyond it. First. The second line of an argument is that since the ex parte ad interim order was refused way back in the month of July 2023, now we are in the mid of January 2025, considerable period has elapsed. Then it is better not to pass any order and relegate the parties to the trial court to decide the injunction application. Third is that even if the court ventures to pass an ex parte ad interim order of injunction, there are three golden principles for granting injunction, which includes an urgency, also the irreparable loss and injury, including the urgency. Order 39 Rule 3 say that it will defeat the very purpose if there is no immediate injunction. So this emergency or urgency is lost. So at this stage, even if they have made out a prima facie case, even if they made out a balance of convenience, but if they cannot show now that there is any sufferance or in view of the urgency, then no injunction. Ex parte ad interim order injunction should be passed. I believe so. This is. Fourth is, you have said that they have not spelled out or averred the clear right to sue. They have not said that how they acquired a right in respect of a, the debtor property. And therefore, if they cannot ever, the clear right to sue means a right in the property.
Right to
then
say
in
by.
whatever, right
Right
to
to
the
say.
subject matter. The challenge, subject matter of challenge, they cannot. I think you are not very serious in this argument that the others heirs should also be brought on record. Having not brought on record,
Already.
I think
Already. ঠিক আছে।
you are not very serious on
No.
this.
ঠিক
I
আছে।
think these are the points you have.
And I said, my lord, that the schedule.
Second is you say that even if it is considered that 1929 deed is
Void.
gone, even by virtue of 22 deed, this property is not included in the
Hodgepodge.
Devottar or
In the Devottar hodgepodge?
the Orpodnama. If
Yes.
it's not, then it cannot be regarded as this.
লিমিটেশন পয়েন্টটা ছিল
Superfluous 34 approach, I am not saying so.
প্রাইমা ফেসি বাড়বে
As a passing remark,
The other one, my lord, is with respect to limitation.
limitation is Order 7 Rule 11, which is already there.
No, even
If you say limitation, then again I have to make certain remarks. We may accept your contention. We may accept your contention. We may repeal your contention. I do not know whether it will impact your Order 7 Rule 11.
no.
We may accept, so it will definitely impact. We may not accept, then it will also impact Order 7 Rule 11.
My lord, classically, it should not.
Because the word tentative is very ambiguous. I do not know the meaning
Classically,
of
it
the
should
word
not.
tentative.
That's why I said classically it should not. But going by the standards that we have today, my lord, I probably will.
That is what I. Anything more, I believe, apart from that, you have asked.
রিকলিং অ্যাপ্লিকেশন গুলো কৃষ্ণার ছেলে এখানে স্বপ্ন আসছে কিন্তু ওরা লিস্টে দিচ্ছে এই করছে তো এইখানে ওরাও পার্টিসিপেট করছে রিকলিং ওদের প্রেয়ার হলে রিকলিং ফাইল হয়েছে ওরা জানে পিটিশনটাতে ওরা প্রেয়ার নিচ্ছে সেল ডিডেড তাহলে 19-এর আগে ডেফিনেটলি নলেজ আর ওরা ওইখানেও কজ অফ আছে এখন শুনবেন কিনা না ওটা প্রাইমা ফেসি
No, it may be inuring to your benefit.
Yes,
It
yes.
may not.
I'll just show your lordship and
Saying.
I'll just show your lordship and then my lord.
What I'm saying, if you say, then we'll have to say something.
No, that is true. My lord. Your lordship would definitely. But if your lordship looks to the plaint ones,
So the limitation point you are taking
no,
there.
I can't give up that point because I say, my lord, it's on the basis of
This
their
is
own
what-
avowal.
This is what you can say the delay is there. If you take a plea of limitation, then you have to.
No, my lord, it's not for me to take a plea of limitation at this
So
stage
you have
at all.
taken it under Order 7 Rule.
Well, that is an Order 711 thing. That's fine. But I was trying to say, my lord, that if I can show from their averments that there is some sort of a delay, my lord, in filing, my lord, the suit, then he's not entitled to an injunction here.
Delay can be.
Is attributable to them.
But a plea of limitation, then.
Lord, I'm couching it in a different way. I am saying, my lord, that look here that he's waited for 9 years. my lord, kindly turns to the Huh.
District judge proceeding trial court.
kindly
Because
turns
the
to my lord
district
the affidavit filed by the Mr. Junior Mr. Banerjee's client.
No, no, এটা plain, এটা plain. এটা plain.
No, in the plaint itself. I'm sorry.
Plain.
Kindly turns to my lord paragraph. কোনটা বলছি?
32 এ যে দেখো
সে
এখানে
দেখিয়েছি
তার 2019 এর কিসের নলেজ হলো ডিস্ট্রিক্ট জাজের যেটা চলছে
Kindly looks to my lord the plaint
But
ones at page
district judge
17. Have a look at paragraph 32.
আর
Cause
ডিস্ট্রিক্ট
of action paragraph.
Yes, where the plaintiff number 2 came to learn about the proceedings before the learned district judge at Alipur. So in 2019, she knew about below the deed. 2019, she knew about the deed. Then in the
stay application
stay application, kindly takes up below page 188. Lordship doesn't have it below.
Have it, then it's your pleading. Oh, their application.
Their application,
88
88.
অরিজিনাল কপিটা দিয়েছি
I
কারণ এই
can't read
ডেটটা
it.
ওখানে নাও
188
পেতে
is
পারে
the PAN card.
না তুমি এটা দিয়ে পড়ো
Below, it's the
original.
part of the
199
plaint itself.
199
Kindly have a look at 199 of the stay application. This is the recalling application.
199 কৃষ্ণা ব্যানার্জি ফাইল করবে
This is the miscellaneous case number 15.
Yes, case number এটা হচ্ছে 335.
335 হলো 217 পেজ
My lord, and kindly have a look at 217 as well.
দুটো
There are two recalling applications.
Who is she?
কৃষ্ণা ব্যানার্জি ডটার অফ
Krish-
আদালতা
Krishna Banerjee is one of the daughters of Ashalata.
I do not know. This Sapna has come.
Shopna is one of the daughter my lord of Ashalata. This is the other daughter of Ashalata. Yes, ma'am. There kindly have a look at
Sure.
151 application, my lord, your lordship sees at 217, your lordship will find Produt Banerjee,
Produt is daughter of son of Krishna
and Produt, my lord, is the son of Krishna. Son of Krishna. And sees the filing date at the top, my lord, it's 20th of December 2019. 20th of December 2019.
the date of file
The date of filing, my lord, of that application, section 34, is 20th of December 2019. I'm only on the delay, my lord, and they had knowledge. Kindly have a look at it. And kindly sees if it's, they can show, my lord, whether it's right or wrong.
Like,
Well, I'll just show it to them.
জেরক্সটা ওঠেনি জেরক্সটা ওঠে
No,
না, না, মানে
217 না।
217 না এই
এইখানটা ওঠেনি।
এই ডেটটা ওঠেনি ওই জন্য বলছি অরিজিনাল কপিটা না
এই জন্য
ডেটটা
অরিজিনাল থেকে দেখাচ্ছি। কারেক্ট। সেই
কেটে
জন্য
গেছে।
অরিজিনাল কপিটা দেখাচ্ছি। দেখাতে পারি? দেখাতে পারি তো? Produt, my lord, is the daughter of Krishna, who is one of the, my lord, daughter of Ashalata.
The son of Krishna, daughter.
I'm sorry, son of Krishna.
আর
So these are all brothers and sisters who have taken different routes.
আর প্যারাগ্রাফ 28 of that
And
petition
if your lordship, I have a genealogical table, your lordship will find that Ashalata, my lord, had Krishna, my lord, as one of the daughters, Krishna, Roktima, Runima, Aroti, and Shopna. Now, Shopna is the one before your lordship claiming to be a Shiva.
রেকর্ডে নেই তো দেখ।
The others have filed a recalling application in 2019 before the trial court saying that there is a sale in of 2015.
প্যারাগ্রাফ 28
So kindly have a doesn't take it from the limitation aspect very well, but takes it from the delay aspect. Takes it from the delay aspect.
ট্রান্সফার প্রপার্টি
Though I, my lord, কাকা বলছে আমি কিছু বলবো না।
না না
So-
limitation হলো একটা for all time to come gone দিলে তুমি interim injunction এ চাইতে পারে চাল at interim purpose তুমি ডিলেতে পাবেন
সেকশন 3 আবার করবে ট্রান্সফার প্রপার্টি when they have up to vote
আর কিছু
So this is what, my lord, our entire thing is. She doesn't show how she becomes a Sheba. Kindly looks to the print once again
no,
for
no,
one.
yeah, I have read it. You did
No,
not
no.
have to.
She has said what the heirs are. She has
Yes,
said.
she has said 333 genealogical, she has depicted. I have seen that.
So if that is so, my lord,
So
from
we'll
the
consider that.
22 deed, how does she become a Sheba?
Let us see.
One aspect. So, my lord, lordship has considered, my lord, 5-fold submission of mine, why she should not get an injunction at this stage at least. Your lordship has compartmentalized it, so I'm not going to trouble my lord any further. Now, my learned senior
Just
friend.
to eradicate the sense that there may not be uh, the points there may not be a consideration of all the points. That's why I jotted it down.
Yes,
So that
better.
just to percolate the message that yes,
You have
everything is
taken
the
it in,
core of the
that your lordship has taken it in. My lord, before Mr. Banerjee now.
আবার কি হয়ে যাচ্ছে
তোমরা ভালো করে বলো ডিলেট ব্যাপারটা।
আর বলার কিছু নেই, বেশি বলে গেঁজে যায়।
বেশি বলে গেছে।
Where to stop you must know.
Very.
Now only thing is this one. Look, I can tell you one thing.
opening of mouth is very important.
কি বলতে পারলাম?
Opening of mouth is very important.
Very important. Sorry,
He will
then
tell you
I-
what is the
Then
important.
I tell you one incident.
No, that is, he will tell you the important.
Just a minute, my lord. His father, Mr. Chatterjee, Justice Chatterjee was appearing in his own case. As for the petitioner, the division bench. After hearing one of our part, it was rejected. On the very next day, Justice Chatterjee came to me, "আরে পয়সা পেয়েছিস?" হ্যাঁ, আমার solicitor দিল না,
কাকা এদিকে এসো।
আমার solicitor দিল না, এখানে
ড্রাইভার বলতে বলবি জানো 5:30
Or is it because of some administrative
No,
problem?
no, not at all, Millard. Millard, may I only come back at 4:15, Millard? Very urgent. 8th order 41, your lordship permitted it.
At 4:50.
It's there in the list, Millard. I'll wait till 4:15. If these hearing matters don't happen, mine will. But if it doesn't, may I come back at 4:15? I'll come and take a try, Millard.
Item 92, 93.
92, 93.
No, that will not take. We'll take up. We'll take up to order 41. We are
Grateful, Millard. Grateful.
who is appearing in this matter.
Item 52.
Then item number 4, my lord,
Where is Mr. Advocate General?
my lord, Advocate General, my lord, engaged in other court, my lord, kindly,
So
but
you prayed for a
my lord,
time.
but I prayed for time on his
Then-
behalf, my lord.
Then,
My lord,
then
kindly accommodate for the day, my lord,
this is not expected.
my lord, kindly accommodate for the day.
No,
No, my lord.
I told you on that day,
Yes.
please consult the Advocate General whether he's available or not. You said on this day he will be available.
My lord, but suddenly it has, my
Suddenly
lord,
that
it has
will not,
changed, my
that
lord.
means that.
Suddenly it has changed, my lord. Kindly accommodate
Matter
for.
has no.
No, my lord, suddenly it has
Urgency.
urgency, my lord. It has urgency.
You argue.
No, my lord, the my lord, Advocate General is there, my lord. I cannot, my lord.
Why? When the Advocate General is there, then the court has to sit idle.
No, my lord.
Then
My lord, for this matter, I am praying for some.
I understand. We accommodated you on.
Yes, yes. Lord, I bow down to your
This
lordship,
matter
lord.
will
Your
be
lordship was pleased to, my lord.
on your prayer, accepting that, yes,
On that day, my lord, I did not inform, my lord. Thereafter, when your lordship passed the order, I informed, my lord. The Advocate General was,
then.
my lord, about to come, my lord. My
Why?
lord. Suddenly, he has stuck in a matter, my lord. Kindly accommodate.
Then next time he will also stuck.
No, kindly
There is
accommodate
no
for.
certainty. Tell us, we can accommodate. Tell us the date that he will not be stuck up anywhere on that day. Tell us. Tell us the date.
Well, any day in February, my lord.
Then-
Any day in February, my lord.
The proceeding is controlled.
No, my lord. Any day in February, my lord.
Tell us the date, no difficulty.
এই যে স্যার না থাকলে আমি কি সমস্যা
Tell us the date.
ক্যালেন্ডারটা দাও না কবে ফেব্রুয়ারিতে ডেট বলো
তুমি কি করে ডায়েরি কনসাল্ট করছো?
না না স্যার
মানে
স্যার
রেজিস্ট্রেশনের করো?
স্যার বললেন যে ফেব্রুয়ারিতে যে কোনো একটা ডেট নিতে ফার্স্ট উইক
স্যার বললেন
স্যার বললেন
স্যার
তার সাথে
বললেন।
কথা বলেছি ক্যান ইট বি অন 6th of February, my lord?
Date of 2025 or 2026.
25, my lord.
We are ready to that.
My lord, Advocate General, I request, my lord, he asked me to, after your lordship, any day in the first week of February, my lord.
Well, kindly excuse me for 6. Well, I'm thank your lordship because I will be in Kumbo. I'm very frank. 6 to 10.
10-এর পরে
হ্যাঁ ঠিক আছে এনি তারপরে স্যার বলুন
5th করতে পারো I can't.
না 5th স্যার 4th তাহলে স্যার 11th রাখুন
difficult. I may not come back.
That's your conversation.
If
Sir, 11th or 12th, my lord.
The bench is not a party to it.
No, 11th or 12th, my lord. As your lordship suits. 11th or 12th.
Everybody
Sir, 11th,
agrees
12th
with
হবে?
But this should be last. Well, this should be last.
My lord, 12. 12, my lord.
And this is well not the appeal of the state also. I don't take that point. Obviously, Learned AG can. He's the director of pension. Probably Mr. Sen is appearing for the appellant.
We do not want to make any observations on
No.
that. An accommodation is sought as the learned Advocate General is engaged in another matter. On consent of the parties, let this matter be listed on 11th.
11th.
To be taken up as first matter.
Passport. At my lord,
First. Yes, call the order 41.
এইটা issue হচ্ছে না।
দেখো আমাদের ঘরে কালকে না রাখা কেন আমার কেন থাকবে
তুই বল আমি তুই বল
My lord, I Item number 3, my lord, specially fixed matter. Your lordship, my lord, tomorrow, my lord, I have some personal difficulty.
Order 41 for a petty law.
No, my lord, I have some personal difficulty tomorrow. If your lordship, my lord, make it not this week, my lord.
Anyhow, yes, next.
আমাদেরটা not this.
এখন order 41
Oh. Anyhow, it was not possible for tomorrow.
Not this week, not this week. Monday.
Write it down. Insufficient sufficiently published on verification of the resolution state. 500 টাকা বলেছেন। Oh, তারপরে ডিফারেন্স পাইতে পারবে। অ্যাথলেট করতে কিছু টাকা দিচ্ছি তো 83 টাকা স্ক্যাম 100 টাকা দিয়েছি। Then what do we have? This was 86. 86. Yeah.
In this matter, their lordship was pleased to direct me to serve notice, but the service could not be completed.
3 weeks time was given.
Yes, we have said, my lord, could not be completed. After that, we got the present address of the opposite party, my lord, will serve, my lord. Only 1 week, we already sent. Only not this week, my lord.
Not this week. The service is not complete. Let this matter be listed after 10 days.
Yes.
87. 87.
Yes. Your Lordship, I am praying for not this week. Advocate on record, not present today because of personal illness. Kindly fix for Monday.
Then let it go out of this. Recover. देखी फाइलটা देखी Gently injunction is used. So thank you. And accommodation is sought that the advocate and recorded English force. Let the matter go out of it with liberty to mention. It's next.
88.
My lord, Mr. Devashish Shah is appearing for the appellants in this matter, my lord. He had to leave few minutes ago due to some very serious personal issues. I am praying for 1 day's accommodation. Kindly take it up tomorrow, my
Will he
lord.
do the case or he has engaged a senior?
He will do the case tomorrow, my lord. Kindly allow 1 day.
Not today.
Applies, my lord.
89.
Point it out.
89.
Defect, my lord. Deficit court fees of 20 rupees.
Deficit court fee has not been put in.
Rupees 20 of the valuation has not been funded.
Direct of sure, the valuation of they have not been. Why you have not put the valuation? That entry was refused.
Yes, my lord.
Yes.
I will pay
Deficit
the
court fee. Time to put in the deficit court fee as pointed out by the additional stamp reporter is extended till 21st January 2025. This is the matter on 22nd January.
my lord.
Next.
90.
I beg to appear for the appellant petitioner. Lord, the order under challenge is, my lord,
ও এটা একটা মোটা কি বলছি 89 852 সেকেন্ড ম্যাচ করেছে আমার করতে এখান থেকে কাজ এই ম্যাটারটা ছিল
Your Lordship has seen, my lord, page 3, internal page 3 of the impugned order says, my lord, that there was a document referred to in paragraph number 5.3 in the second paragraph of page 3 of 4. My lord, it says, be it mentioned that though in paragraph 5.3, Roman 3, defendant number 1 and 2 have stated that they have annexed a copy of a document containing the terms and conditions executed by all the co-sharers by putting their signature on the same, has been filed with annexure A, but no such document has been found. And thereafter, my lord, on the basis of this, if your lordship kindly reads on, my lord, in the next paragraph about.
You have said that there was an oral family settlement.
No, I have also submitted a document containing signature even of my father during his survey when he was surviving. Lord, he had executed a family settlement
Where
agreement.
is that executed?
Yes,
You
that
say
is.
the oral settlement. That is what your case is.
Your lordship
There
kindly
was
takes a
an oral
page.
family settlement.
There is
Page 11, they have annexed one document, my lord.
Where is the document?
Yes, page 11. Your lordship kindly takes a page 11. My lord, this is a document
page 11 is
page 11, and your lordship
Non-judicial stamp.
whatever.
Your lordship will kindly find. Lord,
Was in respect of a position.
Yes,
The word position is wrongly because it should be treated as a position.
Yes.
One can make a family arrangement that how the position would remain.
My lord.
That the plaintiff cannot claim that he should be given a position. But that does not mean that his right, title and interest which he inherited was evaporated.
It has not extinguished.
Says that you are occupying third floor of that premises and other floors are already rented. You alone is realizing the rent. How can you? Will you not give them a...
Lordship kindly considers. Lordship kindly considers one thing. Not here, my lord, it is said that the possession is divided. If your lordship
nothing.
Lord, if your lordship kindly, my lord, reads, my lord, paragraph 2, if I may place, my lord. Mohammed Iqbal will not claim any, will not claim further any position. Yes.
Will
not claim position. So, my lord, the right perhaps has not extinguished. His right, his title.
He's not entitled to have a proportion of the proportionate share in the rent.
My lord, at the same time, while my lord extinguishing his right of possession over this.
And the language is
Possession.
Position. Yes.
Lord, it is stated that Mohammed Iqbal will stay at a certain other premise. Lord, thereafter it is also said.
Mohammed Iqbal will stay at premises number 82 by C. There's no, and that too in the ground floor only. What about the others? Did not say. Then Mohammed Iqbal will not claim any further possession at premises number such and such, means the position because he has been residing there in the ground floor.
He has been residing.
Mr. Bilal will get a position of 21 such and such with the father and 4 sisters. So means the position.
His position is taken away. By this document, his position is taken away. His position in respect of 2 by 1, the property mentioned here,
his right to possess that property goes.
He is not claiming possession. He's saying that please divide, make a partition.
If I may now submit this,
Then
if I may show this
right
document.
is not extinguished
If I may,
by a document which is not recognized in law.
family settlement deed, Lord, that is a question which
then
might
it has
be
to be registered, affecting the involved property under section 17. Otherwise, section 49, you cannot rely upon this document.
that perhaps may be argued before the learned trial court, and if your lordship
not
invites, I may
necessary.
try
It is
to.
a big case where the receiver.
May I,
who has
may
been
I,
appointed as the
humbly
receiver,
submit one thing, my lord.
Receiver is receiving, he is acted upon, my lord.
something, Farhana Islam,
Yes, my lord, receiver is appointed.
who is
Appointed.
who is she?
Not a member of the bar, perhaps.
member of
No,
Member of the.
I'm not on that. I'm not disputing that.
And
There
she's
is, my
collecting
whole
the
case is on
rents,
this
my lord.
document. I need not.
Sorry,
But if I may
see that
only
what is-
submit this, only if I
What
may
is this
submit this.
document?
But only if I may submit this family resettlement deed, not whether it is registered or not. But I fully bow down to your lordship that perhaps registration is necessary, because if any right is created or extinguished, perhaps not section 17 will kick in.
49.
Section 49 registration of document is mandatory, otherwise I cannot.
And that is,
Yes. Lord, may I just place, my lord, once, my lord, if your lordship can.
that is also denied by the,
Sorry.
But section 49, if I
Don't put any impetus.
that.
He's the appellant, he has a right. When
Lords.
the court is putting a question, let him answer.
Lord, may I place section 49 once, if your lordship permits me?
It says that the document which is compulsorily registrable has not been registered. Then in that event, it will not be taken into evidence.
Not be
So
taken.
why so says that if it is a suit for a specific performance of an agreement for sale, then the section 49 will not stand as a bar, or for any collateral purposes. Collateral purposes means just to ascertain the possession. It does not mean that the right title and interest would be demarcated.
I bow down.
And collateral purpose, the Supreme Court in I think 6-7 years before the judgment has said that collateral purposes does not mean that a right would be founded thereupon.
I bow down to that. I bow
You
down.
are trying to found
May I
base
place
your right on the basis
May
of
I
that.
place section 17 once, my lord, the compulsorily registrable documents, my lord, whether it is.
You want a judgment which says that the family settlement affecting the right title and interest of in respect of a HON'BLE property is compulsory registered.
But my case is there has been a family
Under the
settlement.
Transfer of Property Act, if it is a will, then go and obtain the.
There
obtain the probate.
is a procedure for that. But
And
my
can't be
if your
regarded
lordship kindly hears
because
me.
section 63 of the
Lordship kindly
Indian
hears me.
Succession Act will is
But
not
I
in
understand. If
form.
your lordship kindly hears me on this, but this agreement, this document is, my lord, a recording of the family settlement which has already happened. This is neither creating any right nor, my lord, extinguishing any right. If your lordship kindly allows me to place section 17, which if it is a lordship's pleasure, my lord.
Good for partition.
Lord, section 17, if I may place once, my lord.
Yes.
Section 17, Registration Act, Lord, of the
17.
17. My lord, my lord, whether it is compulsorily registrable and which documents, my lord, if I may be permitted to place.
Because we have to say the Transfer of Property Act has to be seen into it. TP Act दिया था.
अच्छा.
TP Act का था. Any immovable property fetching more than 100 rupees value.
This may be interpreted as
the
a
title of the persons that is compulsorily registrable.
Yes, my lord, section 17, quite clear on that, my lord, of the Registration Act. It is very clear on that.
And family settlement, then what is the notion? It is merely an arrangement between the parties with regard to their mode of possession.
With their mode of possession, yes. But I am so deeply obliged, my lord. It is on their mode of possession.
If they claim a right to recover rent from the tenant is not extinguished.
But if the title remains over the property, perhaps, my lord, then
not entitled to recover.
Perhaps then he can. Perhaps then he can conduct.
Title, if you say it affected the title, then in that event, compulsory registrable under the Transfer of Property Act.
But subject
to
correction,
be done without any document.
Or subject to correction, if I may be permitted to place once, my lord, section 70.
Please.
If I may read, my lord, documents of which registration is compulsory. The following documents shall be registered if the property to which they relate is situated in a district in which, and if they have been executed on or after the date of which, date of the Indian Registration Act. or the act came into force, namely instrument of gift of immovable property, other non-testamentary instruments which purport or operate to create, declare, assign, limit, or extinguish.
Correct.
Create, declare.
Create, extinguish. Yeah. Here you wanted to extinguish their right.
I am attempting to draw a very distinction. Here, the extinguishment of the right, the extinction of the right, that is a mere recording. This document merely records the extinguishment of the right of the.
Then it is not registrable.
It has already happened. My humble submission and the case I have run in the written statement.
A very interesting question you have raised. A person on the basis of a non-registered document purchased the immovable property worth rupees 15 lakhs and then was put into possession. Everything is enjoying all the trappings of the owner. And somebody comes and challenges, he says, look, it has already been implemented. Possession has been given to me. I am enjoying, I am discharging all my duties as an owner. So I becomes an owner. Very good. I think one of the finest thing one has to embrace.
That is not what I am trying to submit, because that will be a completely foolish argument to present from this side, my lord.
Sorry.
But
Sorry.
Even in the event that the stamp duty is not properly paid and the registration is not made, my lord, this has to be impounded.
Please kindly consider, there are two facets. One is a stamp duty. Another is a registration.
The mandatory nature of registration.
Stamp duty, impoundable, no difficulty. I can understand under section 33 or 35 of the Stamp Act. 49 is an absolute bar. Except you come under the proviso. Beyond that, you can't. It does not talk about that it will get cured. No. Now, one of the executed is not in the word.
It's not in.
So, how can you get it registered?
Lord, may I come back on Monday?
That is a problem with me because I interact. And the
No,
moment
I'm so grateful, my lord. I'm so grateful. I'm so grateful.
God.
My lord, this document, what I'm trying to place before lordship, this document is a mere, my lord, recording of the family settlement which has already occurred.
I am saying that what is the nature of the family settlement? I have already delivered a judgment on that. Based on at least 4 or 5 Supreme Court judgments.
May I come back on Monday on this?
No. Okay. The receiver has already taken.
Millard, already
lordship
collecting.
Collecting the rent.
Lordship.
No difficulty.
But may I then try my best effort by placing the written statement as well, if your lordship is disposing of the matter?
What?
The written statement,
Receiver
if I may show, my lord, they have
under the
accepted.
parameters of Order 40, Rule 1.
But if I may place before lordship.
Just and convenient to appoint a receiver, then in that event, the court will definitely appoint a receiver. There are certain parameters, and one of the very remarkable judgment on the receivership is of a Madras High Court in late 50s. Which says 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 principles on which the receiver should be appointed.
My lord.
And this is one of the very major ground where the receiver should be appointed. Somebody is asserting or usurping the power as if he has got an unbundled power to do certain things. This is a fit case.
At the same time, my lord, I could have tried to argue before lordship that this property which has gone in his possession has not been included in the partition suit. That has been left out. The property which has flowed to him, the possession of which has flowed to him through this document, that has not been made a part of the partition suit.
That is the case you will ask for whether the suit will ultimately dismiss. But so far as the application, he can bring it by way of an amendment as well.
My lord.
It's not difficult. Or once you say, then it can be brought by in the hotspot. At this stage, we can't.
But may I come back on this whole question, my
The
lord?
receiver is already there. We
My
are
lord, receiver is there. My lord, if I may.
for cyanide,
Lordship.
continue with the receiver.
Lordship, kindly.
Their Order 7, Rule 11 already rejected, my lord.
Order 7, there is a different question. My lord, if I may come
That
back
is
on
also
The
rejected.
ground of non-inclusion.
My lord, that stamp paper they have also on the basis of this mutual agreement, my lord. The entire case was based Order 7, Rule 11, my lord. They were prayed for rejection of the plaint, my lord.
May I come on Monday, my lord? Only on this limited question, whether if I can satisfy your lordship that family settlement.
I think it is too fundamental.
It is if any right is
Not
created
a
or extinguished.
single court, any high court would be able to say that this is the first
I also
principles.
I also cannot argue that
No,
any
this
right
is
is
the first
created or
principle
extinguished.
of receiver. You want
come back
time,
on Monday.
take time, not this week. You go on.
Receiver is collecting rent, but I'm not.
Better.
On Monday, Your Lordship, please.
Yes, it's Monday. Come. Whatever suits you. Monday, next
Monday,
Monday.
my lord.
We don't mind.
I'm so very grateful, my lord. I'm so very grateful for my lord expressing Your Lordship.
But the law is very settled.
I'm so very grateful, my lord.
Great. Being a judgment of justice, S.B. Sinha, this says
Lord,
that
this
the
is
family
very well.
settlement does not take away the right to claim partition.
Lordship.
It is merely an arrangement so far as the accommodation and mode of enjoyment of the property is concerned.
Lordship. Great.
That's the judgment of justice.
I will bring. The affidavit of service is available.
They are appearing. Keep it with you. We are not recording any order.
Mine. So very grateful.
91.
Our boy.
Lordship, I appear on behalf of the respondent.
Somebody was asking at 4:15 to be taken up.
91.
92.
91.
Oh,
92, 93. Lord.
No.
91. 91.
This is against order number 2.
Yes, my lord.
Yes, give us 30 seconds. Who is an executor?
The defendant number 1. Defendant number 1 is the executor. Sorry, my lord. I apologize.
Hijack the right to begin.
I apologize, my
It
lord.
is conferred and order 18 rule 1 upon them.
I apologize, my lord.
Have patience.
Page 72 will I have annexed.
Have you treated the executor as a party?
Yes.
He is one of the beneficiaries also.
Or also one of the beneficiaries, both the sons.
This is what I really wanted to know.
Page 71, 72 is the will. Relevant portion is page 74, paragraph 5.
70?
72 is the will, my lord, you'll also find. And the relevant paragraph is paragraph 5 of the will, that is at page 74.
72.
Yes. Paragraph 6 specifically said,
Just one.
as your worship.
Two sons.
Yes, Pradeep Bokshi and Pravir Bokshi, what are the defendants?
Property is not included. This has not been expressly included.
Yes, yes. All the movable.
Like the omnibus.
Omnibus.
Disposition.
Disposition. And paragraph 7, my lord, initially the father was appointed as an executor.
My husband executor.
And the father if died, then Pradeep Bokshi will become the executor. Next.
Pradeep Bokshi is one of the sons.
One of the son. Eldest son.
Only 2 children.
The daughters are there.
No, there is third children as well.
Yes. Daughters.
Oh, 3 daughters.
Yes. And page 81, my lord. Page 81, your lordship find this Pradeep Bakshi and Pradeep Bakshi entered into an agreement. Page 81, my lord got it?
Yes. Yes. We have filed a suit for specific performance of this agreement.
We have spent, not only we have taken steps for the purpose of evicting the tenants of there. They paid money, they have accepted, I have annexed the bank statement.
Consideration is there. Those
Yes.
25 lakhs have been paid.
Out of 25 lakhs, 4 lakhs paid. Online transaction, 2 is check. 6 lakhs has already been paid.
So you have given a.
And the check was given that has not been encashed. This amount which has been encashed.
After 2023.
It has not yet been returned, but it has not been encashed. I must be candid before your lordship also.
Yes.
And my lord kindly consider the reasons for refusing to grant. My case is not to create a third party interest.
It says that the probate has not been granted.
That is the only ground. My lord kindly consider whether the deed of the pendants is whether the executor has the right to intermingle with the property or not. And the beneficiary can also transfer, because the beneficiary is ultimate the party in these proceedings. And the executor himself.
Is there any objection raised in the probate?
No. As on this day, my lord, till date, no objection has been raised. My learned friend can enlighten your lordship over that proceedings.
My lord, it has been converted into a contentious.
No, my lord. We are not pressing with the probate.
You are not pressing.
No, my lord. I'll tell you, my lord, what happened was that we entered into this agreement in 2022, 8th of July 2022. They paid us 25 lakh rupees checks by 4 checks. That is dated of 8/7/2020. Subsequently, it was a family settlement that since my sisters were facing some financial crunch, we decided not to press with the probate. And then we decided to distribute the entire property among the legal heirs only. On that basis, my lord, we didn't encash the checks. We had intimated to the plaintiff that we are not intending to move ahead because it was mere understanding based on the condition that the probate would be granted, then would be the further proceedings would be taken place. They didn't accept, they have not taken back the checks. My lord, the validity of the checks had also expired.
Write a letter.
No, my lord, it was only a verbal communication done.
Verbal communication. Then.
My lord, the property, half of the, as on date, the status of the property is half of the property has already been sold.
How?
My lord, by a deed in 2024 November.
After and we came before this court.
And my lord, this
can't be.
My lord, this MOU which was entered, it was not a conclusive one. It was.
What are you talking about? You have accepted the money and.
My lord, we have not encashed the money, my lord.
One of the check has been.
My lord, my lord, I tell you that check.
Online transfer is.
My lord, that check, that 2 lakh rupees check, I'll tell you, my lord. My lord, that check doesn't form a part of the MOU as well. What happened was that the defendant number 1 is also a chartered accountant. He happened to meet with the plaintiff prior to execution and discussion of this development. My lord, there was some due diligence that was required to be carried out, for which he has taken an advance fees of 2 lakh rupees, which he intended to return as well. It didn't form a part of the MOU, my lord. And the probate and the MOU. My lord, the MOU was also based on a contingent that the probate would be granted, my lord.
You don't take, then the MOU will remain. You by your act, you want to frustrate the agreement. Then it's not by an act of any other thing. The frustration where you have no. That shows that you are an unscrupulous person. You wanted to avoid it.
But my lord, we didn't encash the checks as well, my lord.
You got the money, and they say there is a part of the consideration money.
My lord, that consideration is wrongly implemented over here. That 2 lakh rupees doesn't form a part of the.
That's your professional fees. Do you have any professional relationship with them?
My lord, there's no written.
Why you will accept the money?
My lord, there was a written document, but it was issued in 2021, my lord.
Possible in law.
My lord,
that. And this is what the MOU has come. The checks have been given. You have not written any letter that we are not.
No, my lord. I accept, my lord. That was not. It was all verbal, my lord.
Verbal. You are a chartered accountant. You don't know the nuances of law.
That was a mistake on that.
And the court has simply rejected because the probate is pending.
But my lord,
And you say that we do not.
the amount that was
we will
encashed,
not continue with the probate.
my lord, the amount that was encashed
Right.
doesn't form a part of the MOU, my lord.
In a suit for specific performance of an agreement for sale, an application for
Other side is not here, no caveat.
So everybody came for 450.
The RERA matter. Complaint made saying that how could you have 48 car parking spaces outside?
First is the defect, the hurdle of defect.
That is what I am nervous about.
That is what we are also to see. How much? Sufficiency of the court fee stamp herein is subject to the consideration of the Honorable High Court as Court Fee Act and statute are silent on this affair. Good. The instant appeal arises out of an order of the Western Conference. Instant appeal is thus wrongly classified as FMAG instead of SAT.
Sir, I thought that it's an appeal under RERA Act. No?
RERA Act
54 no.
indicate appeal valued at rupees 1,000. Development project 1,000 টাকা হয়।
Huh? I was wondering whether it would be second appeal.
No.
Sir, may I read it for your lordships? Any
You
person.
did not have. I get distracted once
Yes.
you read it. So let me read in my own way, then you.
Yes.
বলছে কি সেকশন 100 এ যে কনসেপ্টটা নিয়ে এসেছে সেই জন্য ও বলছে যে এটাকে সেকেন্ড অ্যাপিল হিসেবে ট্রিট করো। আমার মনে হয় ইট উইল বি কনস্টেবল কি
That appeal from order is miscellaneous. Sir. I'm sorry. Thank you.
How the income tax appeals are being registered under section 200
Yes.
2 or
এটা বার করো না লিস্টটা বার করো নাম্বারটা কি হয়
how these income tax appeals are registered?
260A.
That is what I'm saying, under 200 and something.
Jurisdiction. ওটা original side এ নয় special jurisdiction. Original side হয় special jurisdiction করে। তো original side হয় special jurisdiction করে, ওটা appellate side হয় না। Income tax 260
হ্যাঁ 260 appeal নাম্বারটা কিসে হয় এখানে ফোনটা
What is the categorization? I just wanted to know the
ITAT or ITA something. Income tax
appeal tender, then
High
income
Court.
tax.
I am talking about High Court,
Yes.
how it is registered.
Income tax appeal. ITA.
Appeal tender, then
ITA number.
Sure.
That's what. I'll just original side list bar karo. Yes.
No, it is in the original side or it is always in the appellate side also.
Original side.
No, original side.
Original side.
Now, my lord,
Original side.
CXA
It has central
is
excise.
service tax.
Central excise.
Central excise.
CXA is central
excise.
excise.
Then, my lord,
Again,
ITAT, which is, my lord, under income tax.
Income tax appellate tribunal.
No, that's the number given. Kindly see, below.
Income tax
It's
appeal.
tender number.
Admit হওয়ার পর it becomes an
Ever,
It becomes ITA.
একে বলো তো রেজিস্ট্রার আইটি আর লিস্টিং একই আছে না আলাদা আছে? তাহলে দুজনকে ডাকো।
আলাদা হয়েছে
দুজনকে ডাকো।
No, there is no classification in our list for RERA appeal. I looked up.
Let me think, because now the RERA is coming. Now there will be a flow of
Yes,
the matters before the High Court.
yes.
So if the first matter is now being dealt with in a particular manner, then it will not create any anomaly in future. Because the identification is very important.
Very important.
So the language I find, it is the same language of section 260 or A of the income tax.
Statutory appeal.
That too on a substantial
Substantial question of law. I have prepared my question of law for that reason.
No. So provided it is a question of
Yes.
every question of law is not a substantial question of law. The distinction is there, real. And what is the merit we will see. Let us see. These are the all technical and procedural parts.
Yes, yes.
We'll take
But
care
this
of
is
that.
now going to happen
But
on a
how can you evaluate it as 1,000 rupees? Such a big infrastructure project. The appeal is valued at rupees 1,000.
Now, this is regarding, I can, your filing fees. কি হয়েছে? বসো না, এরকম বসো না, বসো এখানে বসো, বসো। So that is the filing fee of a RERA complaint before the tribunal. So same amount has been put here.
special jurisdiction.
Tough reading. হ্যাঁ, আমার সঙ্গে রোজ হয় এটা আজকে। তুই একা এখানে ঘুরে বেড়া।
Yes, I went and I moved it. Yes, even before it, I'll tell you a lot. Yes. 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 May I, Milord, may I just give a little more of the background? Just, Milord, in 2 minutes. 48. So there's just one more sentence left. One more. Milord, this change was in 2017 and in 2018, prior to HIRA coming into effect, before HIRA came in West Bengal, prior to HIRA, so concurrence of two-third majority required under Section 14 HIRA and Section 14 HIRA wasn't even required. So when this Section 14 RERA says, if you want to amend your plan, you need concurrence of two-third majority. So, Milord, my change is prior to HIRA or RERA coming into operation. So, I did not need two-third majority. And when HIRA came in 2018, Milord, RERA is recent, Milord, after the setting aside, I'll just tell you, 21. Well, Act is earlier, but in West Bengal, yes, but it wasn't applicable in West Bengal because West Bengal, Milord, applied HIRA. Supreme Court set aside HIRA and said that state cannot legislate. Milord, the first is 2018 before HIRA. So I can do what I want. I don't need his concurrence. And to show that, we filed affidavit. Milord, your lordship's permit, I come with a judgment with a document after CAV, your lordships keep it. So, Milord, this is now what is happening. And Milord, one further. objection to this. I mean,
Not have any.
no, I don't want to, my lord. I want the point
I
to be
realized
decided.
what you wanted to say. That's why I did not.
And the other thing is, my lord, the second matter is there is a dependent order where, my lord, the RERA said that I can't decide without this affidavit, and it referred the matter to the appellate tribunal. Appellate tribunal said that you have no business immediately decide. So, my lord, that order is also subject matter of the second appeal. It can be heard together, my lord. There is no difficulty.
Since the point involved in the instant appeal is similar and identical to the substantial question of law framed in Agir appeal and naam diye dao, let this appeal be tagged with the said appeal and be heard analogously.
Gratefully.
The interim order passed in the aforesaid appeal shall also be deemed to have been passed in the instant one.
Grateful, my lord.
Anything more?
No, my lord, joy arguing this before RERA.
Why?
No joy arguing this before RERA. My lord,
Why?
2 hours we tried, no effect. That this tribunalization is.
No. Why you say no?
I'll tell your lordship truthfully why.
Reason later on after the come and tell us. There is a reason why I will tell you.
I'll
I
come and
wanted that information.
I'll come and give your lordship. Just before your lordship's rise, I'll come.
Yes. No, just after I rise, come and tell me. Not in the so open podium.
Okay.
What's the next? 93.
93 same as
93 কোথায়? Oh, 93 হয়ে গেছে. 94.
My lord, I appear for the appellant.
I'm for the respondent, my lord.
My lord, yes, my lord,
My lord,
okay, lordship.
Lordship, Mr.
Bhattacharya is appearing online, Lordship.
Appeal from an order of ad interim refusal.
Mr. Ghosh, one second. I'll just, my lord, this is a matter, my lord, where your lordship had put a query to me as to whether insufficiently stamped agreement can be relied on for the purpose of obtaining an injunction. And my lord, then I had relied on that NN Global larger bench. And after hearing me, my lord, your lordship was pleased to observe that we should serve a notice to the respondent. And that's why, my lord, I tried to move it ex parte. And then, my lord, we have served the respondent and Mr. Ghosh is appearing for the respondent. So, my lord, the question, my lord, which fell from your lordship is that
Now, should we decide it? Now he has come. We can fix a short date for affidavits and let the injunction be decided. Come back. Finally, we'll decide this point.
Yes, absolutely.
No difficulty.
You are then, my lord, kindly makes it a frames a time frame, my lord.
Yes,
absolutely.
The matter was now after hearing the respective parties on 3rd December 2024, this court felt that the points so raised in the appeal it's to be decided in presence of the other side, and therefore without So Bhattacharya, what more precaution I can give? Everything I have provided.
My lord, grateful, my lord, grateful.
Obliged to lordship.
Application disposal.
Appeal and applications disposal.
Obviously.
That would have been a very interesting point to argue before your lordship, my lord.
Come, let you come back. Let us see.
Great.
Come. Yes. Call the next.
In this matter, my lord, I am appealing for.
The appellant, my lord. He is on his leg, my lord, from courtroom number 237.
Who is the advocate and records? Somrat Chakraborty.
Yes. Yes.
We have to ask you.
Now he has
My lord,
come. Argue.
My lord, in this matter, I am appealing for respondent 1 and 2, my lord. Kindly direct them to sub copies, my lord, so that next day I am. Next day, my lord. Kindly fix the next day, my lord.
No, some a copy.
Any day on Monday, anywhere on Monday, my lord. Monday,
Give him a copy. Give him a
Monday,
copy immediately.
kindly take it on Monday, my lord.
Don't be so impatient. First you get the copy. We are ensuring that the copy is served on you.
My lawyer friend is asking.
Why FMAT?
Remand. Remand.
Come ready on Monday?
Monday, Monday.
Not on Monday. On Wednesday, we are giving you more time. Take whatever instruction you intend to take. Come ready on the final hearing.
Yes.
We'll dispose of here.
Yes,
No difficulty.
Monday.
Yes. Dispose of.
Or about here.
So what? Copy has been served.
Yes, yes.
The respondent number 1 and 2 appears and prays for a service of the copy of an application. Implied admission. Yes, next.
This is all I am appealing for the appellant.
Yes. How is your mother? Fine? Because last time.
Yes, yes. I have to rather
Adjournment was.
Behrampur. There's no one, but she is not willing to come over Calcutta.
Yes.
Fresh air.
Take a second. It's again a remand. Which court? Murshidabad.
Yes. Can I come back on
What's the
Monday?
suit for?
Monday, my lord.
Why? Not ready.
Ready, but
No, tell me straight away.
come on Monday, my lord. Yes. Once your lordship passed out any order, my lord, it will only not today.
Not today.
Only not today.
Next.
It will do set with Josh. I have to get it photocopy for my lord. That was not done. That is the problem, my lord.
97, I am praying for not today. Mr. Sen has
Why?
briefed the matter and client instructed me not
Where is
to.
Mr. Abhishek Shah? You are the advocate on record.
His client instructed me not to do. Mr. Sen has
you
briefed
do
the
it.
matter.
You are the advocate on record. Do it. Open. Tell us fact.
I don't have,
There you
I
go.
have no knowledge in the matter.
What are you talking about? You have filed the memorandum. You have filed the application. You don't have a knowledge. No. Argue. Tell us the facts. No difficulty. Tell us the facts. Yes.
An application in connection with the appeal challenge a judgment in Miss case number 90 of 2022. The suit is sir, one Bipin Bihari RD during his lifetime made a will. Bipin Bihari RD died on 18 July 2000.
Yes.
After the will is made dated 5th July 2000, which was duly registered 6 July 2000 at RR Kolkata.
Yes. Yes, yes.
Priya Datta filed the executed. Yeah, Priya Datta executed in this will. According to will, Priya Datta filed a probate suit before the Alipur court.
Yes.
The copy of the will annexed A and B.
Yes.
After that, execute Mamata Addi immediately after the date of tested are known that 8,50,000 for the state was and deposited in her personal without any intimation information to the original petitioner.
Yes. Yes.
After the 26th August 2000, the original petitioner called upon the defendant number 9, Mamata Addi, to return the monies appropriate by her, but the defendant number 9 no reply of that letter, and after that, Priya Datta filed this case 5th July 2000. The will and testament at 5th July 2000 for grant of probate. And on 30 September 2000, the original petitioner filed and
yes.
On 30 September 2000, Priya Datta filed Order 41, Rule 1 for restraining withdrawing the money by Mamata Addi and not transferring the Bipin Bihari property to a third person. In this regard, Priya Datta got an injunction order by the Raleigh trial court.
Yes. Then
on 23rd November 2000, defendant number 1, 2, 7, and 9 filed separate application opposing the grant of probate of the registered will, which file executed by the Priya Datta.
Yes.
After that, the probate matter transferred into the original suit. The register number is OS 192 of 2000. After that, the notice is served upon the all.
Bill is admitted. The appellant is directed to serve the copy of the stay application upon then
Last day I told them, last day also.
not
that
proper for a junior. At least he should know the fact. He should memorize the fact.
And this type of
Law, gradually he will learn. There is no difficulty. He will learn gradually. But the fact he should know. Yes.
Lordship, I am for the petitioner. Lordship, advocate on record, petitioner.
Sanjay Mukherjee.
Sanjay Mukherjee is in the hospital, Your Lordship.
But here, the food value is 61,000.
You can't take it out.
No, I am not in his presence.
But it is not indicated.
But from record it reveals the food value.
No, food value is 61,000.
61,000.
So,
61,000. That will be the appeal will pay.
what is the jurisdiction of the civil judge senior division?
Suit filed in the civil judge before the learned civil judge senior division.
Correct.
The appeal up to the 1,50,000 before the land
District judge.
before the
district judge.
before the learned district judge.
What is the jurisdiction?
Let Mr. Mukherjee come. आज hospital आ जाए की बोलो.
Not a joint. When he can come?
Next week, any day next week, Your Lordship. Kindly make it not this week, Your Lordship.
Will he be discharged from the hospital?
His mother-in-law is in. He's not.
Not today.
Lordship, not this week, Your
Then
Lordship.
it will go to next Wednesday, sir.
Grateful.
Yes. After 40. Anybody who is there, both sides?
46.
45.
Okay. মানে 45. I am for the appellate.
Sides?
Yes.
Hey.
Whether ready to do, it's there, whether he's ready to do.
This is my appeal. This is my appeal.
Otherwise,
There is an interim order. Yeah, already there is an interim order.
Already
Yes.
there.
There is.
What is this application? 1 and 2?
Oh, sorry.
What are these applications?
One application for condonation of delay and another application.
I want the appeal to be heard out on merits because on this outcome will depend the outcome of many similar matters. They are withholding the retirement benefits after 38, 37 years employment. Paltry sums like 12 lakhs. This is a Group D staff.
So whether they can be held, on what ground? They are
They have paid my salary for 29 years.
No,
This is
not by the state government. Not by the state government.
KVK.
I am under a central scheme, but Malad, after that I was transferred to a sanctioned post. A sanctioned post meaning a post sanctioned by the state government. For such transfer, permission of the state government is not contemplated.
There is another matter pending on this ground.
Yes.
We are hearing this matter.
Yeah, but by
It is relating to KVK.
Not KVK.
Vidhan Chandra Krishi Vishwavidyalaya.
That may be so, that the employer may be same. The employer may be same. But if I am transferred to a sanctioned post, the stand they are taking, section 33A stands in the way. That is not correct. If the transfer is to a sanctioned post.
That was a case of another university, I believe.
Vidhan Chandra, BCKV.
That is what there what has happened, that certain colleges, they were under the project, then they came under the project and
central government scheme.
You will get lot of difficult questions to answer.
Yes,
I am assured.
So agitated. There what has happened, that these employees, they were under there was a contract which was entered into with the university and the central project, where all these employees under that particular project, they were taken as the employee of the university. So they went there. The university was taking care of everything. Suddenly, they wanted the GPF or CPF. Central government was giving a CPF. They wanted a GPF.
No, in this case.
So their contention was that once I am adopted or co-opted as an employee of the university, then whatever the service conditions of the university staffs are, I am entitled to the same treatment.
Many things are similar, but
And it says that the university was saying that you were under the central scheme. There was a project, and the project is not perpetual in nature. The moment the project is stopped by the central government, you are no longer with us. Your service will also go.
coterminous. That's the term.
They were contending, no, once we become an employee of the university, maybe under a contract, once you have taken, then my services are to be regarded as the services of the university. And whatever the service conditions of the university staff are, we are to be adopted. Similar arguments.
Many things are similar, many things, but this, from day one, he was a university employee. From day one. From day one, his appointment letter says he was a university employee. And then for 29 years, the state government, that is the reasoning of the Honorable Judge. 29 years.
Let us dispose of the condonation first, then we'll fix the matter, because that is also being hard.
But this is a patient on, his pension is being given. Just the gratuity and the leave salary are being withheld. And they now say pension is being given erroneously. 29.
Stopped pension.
20 now, they're not.
The same
Because-
single judge delivered a contrary judgment.
No. Here, 29 years salary, there for a few months. It's not similar.
And he retired in 1991.
Mercifully, the appeal is before my lords. That is why they have not stopped pension.
No, he retired in 1991 and his petition filed in 2023.
Who?
Anyhow, how much days delay?
163 days.
What do you say?
I want the outcome of this to be decided as fast as possible. Because a series of writ